Reservedly to the House.
Mr. Speaker.
I call the honourable member Dennis O'Rourke.
Thank you, Mr. Speaker. The Victims of Crime Reform Bill amends and improves the Victims' Rights Act 2002, the Children, Young Persons and Their Families Act 1989, the Parole Act 2002 and the Sentencing Act 2002 to provide better for victims of crime generally, to broaden the rights of victims of serious offences, to provide more opportunities for victims to be involved in criminal justice processes, to ensure victims are better informed of their rights, to increase responsible government agencies' accountability and responsiveness to victims, and to achieve consistent victims' rights in all adult and youth criminal jurisdictions. These are very good objectives. The Select Committee has made some sensible amendments to the bill as it affects the Victims' Rights Act 2002. It has removed the definition of address in Clause 4.1 to remove the reference to text messaging, and that makes sense. It's difficult to confirm that a text message has been sent and received, and text messages can be intercepted by other people. And cell phone numbers change frequently and may be reassigned. So for all those reasons, it's unwise to allow text messaging as an electronic means of sending notices. Clause 10 of the bill is also amended to ensure that reference to all of a victim's contact details in court would be restricted to ensure their privacy, and they will appreciate that. Clause 17 will now require the prosecutor to find out from any victim all relevant information about the victim's injuries, property loss or damage and other effects of the offence. So this can be taken into account for the purposes of the Act, and in particular under Section 21, consideration of those matters for sentencing purposes, and that of course is as it should be. There are also several worthwhile amendments and improvements to this Act, to the requirements for notice to victims where offenders are released from detention, abscond, are released on bail, are recalled, are convicted of breaches of bail or die. And in Clause 21, Section 37.2 of the Principal Act will now specify that a victim of crime committed by a person or offender who is compulsorily detained in a hospital or facility must be given two notifications about a person's leave. Firstly, the first unescorted leave of absence outside the grounds of the hospital or facility, and secondly, their first unescorted overnight leave of absence. And I think that's an important amendment which ensures that victims would be informed when a detainee was reaching the stage where their treatment is involving a transition back into the life of the community. Victims need to be aware of this and shouldn't have to find out through the news media or some other informal source. Moving on to the amendments to the Children, Young Persons and Their Families Act 1989, one welcome amendment to that Act is Clause 38, which is amended to allow victims and their representatives to bring in one or more support person, subject to any limitation imposed by the judge, to youth court hearings as of right, without having to seek permission of the judge. This has been a disincentive to victims, having the support they so often have needed. And there has been no purpose in the consent of the court having been required. So that's a good new provision. Another important change to the Act is the new clauses 38A and 38B. 38A requires victims of offences committed by a child or young person to be notified should that child or young person abscond. And 38B requires that victims of offences committed by a child or young person would be notified should that person die in a youth residence. Again, it would be most unsatisfactory if a victim had to find out about things like that from the news media or some informal source. With regard to the Parole Act 2002, The committee very necessarily, I think, amended Part 3 of the bill to restore a victim's rights and entitlements that were incorrectly removed by the Parole Amendment Act 2007. So, these would be reinstated as to victims' participation in the parole hearing process. Victims would therefore be informed about the process and how they can participate. They would be informed of their right to be interviewed and so on. So all of those, I think, are very important things to reinstate, and it's strange that they were ever deleted in the first place. Lastly, amendments to the Sentencing Act 2002 are aimed at improving the restorative justice process. Clause 44 inserts a new Section 24A requiring the court to adjourn proceedings to allow an inquiry to determine whether restorative justice is an appropriate thing to do in the circumstances of the case. And I agree that it is important that consideration be given to whether a victim wishes to participate in a restorative justice process, because they don't always wish to do that. The amendment explicitly now includes the wishes of the victims among the matters that the inquiry must consider. You would have thought that was common sense to do. Well, it didn't used to happen, now it will. Overall, New Zealand First sees this bill as another very welcome step forward in the emerging movement to do more to support and consider the rights and needs of the victims of crime. The one area I think we haven't possibly thought about enough is where nobody is convicted of a crime, but where there is a victim and where there has certainly been a crime. Perhaps we need to give more thought about how we support people in those circumstances, but at least this bill provides some very welcome and very positive steps forward. The committee had received and considered 34 submissions and heard 12 submissions, and it has been a good process, and it will be a good piece of legislation as a result. For all those reasons, New Zealand First unreservedly supports it.
I call the honourable member Alfred Naira. Kia ora.
Kia ora, Mr.